Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host. I probably sound different, and I am blurry as all get up. Oh my goodness. Hold on, I'm going to fix that. Whatever. Why would you be focused there? Oh my God. What a disaster. Here we go. Hey, there we go. Sorry about that. Oh boy. I probably sound bad because, believe it or not, I left my microphone USB cable in Minnesota because why wouldn't I? Why would I bring it here with me? So there's that. But hopefully I sound okay. As for the blurry cam, that's just that was just a weird autofocus thing. All right, guys. So, hey, what's up? Welcome. I'm your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota, currently located in Florida. And today we've got some documents that dropped in Meyer versus Waid. And we're going to get into them pretty quickly here. I don't have, I'll let you guys in on a little secret. I'm at Disney. Sort of. We're off property now, but tomorrow I will, of course, be on property at the park again. And because of that, I have to be up early. Yeah, I heard Florida has a Best Buy too. I couldn't get to one today, and I tried to get one at Target, and they didn't have the right cable at Target. So there you go. But we're going to pretty much get into these documents. I am so close to this flipping camera. We're going to get into these documents. As you know, of course, well, now today here in Eastern time, but tomorrow for those in Central and Pacific time still, and Mountain. Is anybody actually in Mountain time? Like, does that exist? Is that a real thing? I don't know. But tomorrow, the appeal brief is due for Vic. Vic's appeal brief is due tomorrow, and so I will be making an effort to cover that as well. So look for you guys trolling, pretending you're in the Mountain time zone. Nobody's in Mountain time. It's not real. What are you even talking about? Never even heard of it. Tomorrow we will be covering, assuming nothing crazy happens, I'll be covering the Vic case, the Vic appeal brief. And I do believe we will see something along those lines filed tomorrow. If it's not filed already, I don't know. I haven't checked. I doubt they would file it on President's Day. But yeah, so we'll be covering that. So brace yourselves for that show. Should be pretty interesting to see how they lay out the argument as to why the appeals court should overturn the decision of the trial court. And I think there are several reasons that they should, but it doesn't matter what I think. It only matters what the appeals court thinks. So we'll see what arguments they put forward, and then we will check out what the appeals court says as the case goes on. Is there anything else I need to cover before we just get started? I don't think so. Like I said, I don't think this is going to be a super long show. So if you have questions about this, I will try to answer them on this stream. If I miss something or something is confusing you, I'll probably do a follow-up show at some point on this. We will see this case start to move. It's moving at a glacier's pace, but it'll start to move. There probably won't be a lot of documents, though. because they're going to be entering the discovery phase and all of that stuff. But we're probably going to see a motion to dismiss for failure to state a claim, because that's kind of standard stuff. They've done their jurisdictional attack. Now they're going to attack the sufficiency of the pleading itself. And I know that because you always do that in a federal civil case. It's a 12b6 motion to dismiss. It's basically a standard operating thing because, like the TCPA, in some ways, it's a one-hitter quitter, and you got to do it. But the other reason I know is because I have skimmed these documents and I've seen some of their affirmative defenses, and one of them is failure to state a claim. So they're obviously going to make a motion on that. The affirmative defenses are not motions. So you can't just rely on the affirmative defense and say, well, I did it. I said it there. That's not how any of this works. But we are going to go through this document and take a peek. But the lighting in here is awful. Just a second. Wait a minute. Oh, baby. That's a little bright. Maybe we should have it bright. Got to outdo the screen. Less shadows. So anyway, so yes, I did do. If you are watching my, sorry. If you are watching my Twitter feed or my Instagram, by the way, I am posting plenty of pictures on Instagram over this trip. Although I told you guys exactly what you would get. If you made fun of my dad shorts, you were going to get only pictures of shorts. So you can check out my Instagram if you want to see that. I don't know why anybody would, but you can. I also posted a massive bowl of ramen today from a place called Super Saiyan, a DBZ themed restaurant. It was good. It was good food, but I ordered the biggest bowl of soup I've ever seen, and it wasn't even the biggest one on the menu, but it was ridiculous. So it was delicious, though. I have tons left over. I probably won't even get around to eating it, but I'll just make fun of starving people, I guess, with that. I got to meet Toy Bounty Hunters. I know many of you guys know who Toy Bounty Hunters is or are fans of him. And I got to meet him today. That was really nice. So we had a nice little chat. So that was cool. All right, should we get into this? Let's get into these documents. So here's the first one. We have a couple documents here that we'll do. Because this is just kind of a funny one. It's not really funny. So I'm a liar because this isn't funny at all. This is a request for further extension on the deadline to file their TCPA motion. It's the comedy around this stems from the fact that the TCPA motion was originally suspended pending the jurisdictional question, right? They wanted to resolve if the court even had jurisdiction before they would file their TCPA. They got permission to extend that TCPA motion filing deadline to 14 days after the court ruled on jurisdiction. In the meanwhile, since that only took a year, there was a major Fifth Circuit decision that went ahead and came down and said, actually, the Fifth Circuit doesn't recognize at all the TCPA. The TCPA is not valid in a Fifth Circuit, in the Fifth Federal Circuit. So, no, Texas federal courts do not recognize the TCPA as valid. And they shouldn't, because no one should. It's a disaster of a law. This is apple juice. This looks like whiskey. It's not. It's just literally apple juice. But since the Texas Court of Appeals ruled on that, they're asking for an extension on filing their TCPA motion. And the extension, it's not a definite extension. It's an extension to basically, if the Supreme Court reviews and overturns that appeals court decision, then they will file their TCPA motion. So let's take a glance at it. Oh no, that's not what I wanted to do at all. This is not my stuff. This is not my normal broadcast stuff. It's not apple beer. God, I wish. It's literally Mott's apple juice. That's all I have. I don't have anything else to drink in this place. This and milk. Oh, real quick. Let's get this out there. Universal Studios is a far better theme park than Magic Kingdom. Magic Kingdom, wow. No, not good. Universal Studios, pretty cool, pretty legit. But Magic Kingdom is garbage. Tomorrow, we're going to, where are we going? We're going to Disney's Hollywood Studios, and Animal Kingdom, which I think are probably better. I think those are probably better than Magic Kingdom, but Magic Kingdom was not good. It was also like the busiest thing ever. Going to Epcot on Wednesday. Yeah. When we went, I mean, there were so many people. It was just embarrassing. Okay. Sorry. Gelth Walker says, Nick, here's to refill your broke wallet. Can't stay late. Much apologies. Look up the Shane Holmesburg attack on LJ Mangina. It's funny as hell. Enjoy the rest of the trip and stay safe, mate. I mean, I think LJ Montello, I was going to make a joke about how she should probably watch out for Shane because he's dangerous, but I think she's too old for him. So anyway, yeah. Magic Kingdom has the best ride for single men, Tinkerbell character actors. No. Don't do that. Disney doesn't drain credit cards. Disney loads credit cards. Credit cards are debt cups or bowls or whatever, and you pour debt into them. And then they overflow. It's perfect. Okay, here's a document here. Unopposed motion for further extension of deadline to file TCPA. Mark Waid files this unopposed motion for further extension. In support thereof shows as follows. Defendant filed an unopposed motion to extend the deadline to file a TCPA motion to 14 days after an order by the court deciding the defendant's jurisdictional motion, i.e. denying in whole or in part the motion. Court entered an order granting the extension on November 27, 2018. Yes, it was that long ago, and further entered an order confirming that deadline on August 2nd, 2019. And yes, that was also that long ago. The court entered an order denying in part and granting in part defendant's jurisdictional motion on January 29th, 2020, making February 12th, 2020 the deadline for defendant to file a TCPA motion. Fifth Circuit recently held that the TCPA does not apply to federal court actions. See Clock versus Watson. That decision creates a circuit split, as indicated in the Clock case, such that the Supreme Court could take up the issue of whether state anti-SLAPP statutes apply in federal courts. However, in light of the current state of the law, defendant does not want to take up the court's time with a TCPA motion at this time, and therefore asks the court to extend the deadline to file any TCPA motion to be the same deadline to file dispositive motions, which would allow more time for the law to potentially develop. By agreement of the parties, a deadline to file dispositive motions is November 27th, 2020. So dispositive motions would also entail, their motion to dismiss, anything like that. So they have until November 27th, 2020 now to file their TCPA. That's only in the rare case that the Supreme Court not only takes up the TCPA issue, hears the issue, but also issues a decision in favor of keeping the TCPA applicable to federal court. All of those things have to happen prior to November 27th, 2020, and none of them have happened yet. So the Supreme Court would have to take up a case, then they'd have to hear it, then they'd have to issue their decision. And the likelihood of this happening by November 27, 2020 is extremely, extremely low. So, and then the TCPA permits the court and the parties upon agreement to extend the deadline to file a TCPA motion. It does. They conferenced about this. They decided, you boys, Zach's attorneys decided not to fight it, which is fine. There's not really a big fight to have here. And so they agreed to the extension, and there you go. Frankly, if the case gets along much farther, a TCPA dismissal would be pretty unlikely anyway. So, but as it happens, they're not fighting it, and it will just they'll have until November 27th. That's it. That's this whole thing. And then there's a proposed order that they've put in that the judge will sign because they both agree. I mean, the judge could, in theory, not sign it, but he's gonna. There's no reason for him not to. So that's the short document. Let me get out the answer document, which is a little longer, but really not much. Answer documents are typically pretty short. What is this? I don't want this. Go away. Answer documents are typically pretty short because you're really just going through and saying yes or no to the answers or to the questions raised in the complaint, which maybe I should get that First Amendment complaint up, actually. We can kind of go back and look at it if we need to. Let's see. Okay. Complaint plus cover sheet. Where is it? Oh, come on. I thought I had this thing. Is this it? What's this? Exhibits. No, these are motion to dismiss. This isn't it. Let me grab it real quick. I'm sorry. I thought I had it on this computer. But apparently, I don't. $40. Here we go. I know I've done a show on this stupid amended complaint. All right, let's pull this up here. No, go away. All right, here's the First Amendment complaint as well. So as we go through, we can just take a quick reference as to what questions they're answering, what accusations they're answering. Just a second. This is the piddliest cup of juice ever. I'm right here, though. Oh my goodness. All right, here we go. So here's the First Amendment complaint. So we're going to pretty much skip these parties questions. Obviously, these are the parties, but let's see what they got. So the defendant lacks the knowledge or information sufficient to form a belief about the truth of the allegations in paragraph 1 of the complaint and therefore denies it. So that Meyer lives in Williamson County, Texas. This is, of course, this is consistent with his position so far, as he doesn't know that Meyer lives in Texas. He has no idea. Never heard of Texas or Richard Meyer before. No, this is a standard way you answer these questions. If you don't know for sure, you say you don't know, because you don't want to make an admission that might hurt you. There's really nothing wrong with this thing. It's just kind of funny because his defense has been, well, I didn't know Texas was a place. Psychofire says, have some money I won't give to Atlas USA after they bent the knee to re-shit era. Is it a good idea to go to the Atlas USA channel and dislike bomb P5 Royale vids and let them know their real fans aren't SJWs? Hashtag not my persona. I mean, I don't specifically encourage brigading attacks. I think you vote with your wallet, but I mean, you do you, fam. Catch you later, Gelf. See you, buddy. All right. So he admits who he is, at least. He admits that he is Mark Waid. Jurisdiction and venue. While paragraph 3 of the amended complaint contains legal conclusions to which no response is required, defendant denies that the court has jurisdiction over him. So he's maintaining his denial, even though the federal court has found that it does have jurisdiction over him. Court lacks personal jurisdiction over defendant as to each of plaintiff's claims. I mean, it doesn't, though. The court has decided that it doesn't, but he can deny it. While paragraph 4 of the amended complaint contains legal conclusions, defendant denies that venue is proper. So they can deny these. It's kind of like preserving them for appeal, although, you know, they don't really need to do this to preserve it. But I guess you might not want to admit it. So there you go. RZEQDW says, over the past few weeks, I've become paranoid and convinced that coronavirus is world-endingly bad. Put this money towards your prepper fund. Ooh, I'll be digging a homemade cold storage basement in no time. Which is great, because if you don't use it for the apocalypse, you could just store bodies in it. Factual background. They have a footnote on factual background. To the extent any response is required to the headings in plaintiff's amended complaint, defendant denies the allegations in the headings. You're not really required to respond to the headings, but here you go. Meyer's passion for superhero comics. No, he doesn't have that. Defendant states that the mentioned books speak for themselves. Otherwise, defendant responds to lacks knowledge and information sufficient to form a belief. So this background on Meyer, he's going to deny anything that has to do with Richard Meyer, right? He doesn't know anything about Meyer, so he claims. I mean, he knows enough to call him a racist and a white supremacist and to ruin his business and to say people shouldn't work with him and all of that stuff. But he doesn't know who he is. Other than that, though. Other than that. Diamond Duck, who said I was going to dig the cold storage on my own property? Other than enough to know that he should ruin Richard Meyer, he doesn't know anything about him. So that's nice of him to say so. He's going to say this for all of these things. Lacks information and knowledge about all these. So we're going to skip down to paragraph 11 and take a look at that. Because, you know, these are all about your boy Zach. 5, 6, and 7. Creation of the YouTube channel 8, 9, and 10. Then in 11, we've got a little bit more of an answer. Okay? 11, so it says, defendant lacks knowledge or information sufficient to form a belief about the truth of the first sentence in paragraph 11, therefore denies the allegations herein. As to the second sentence and fourth sentence in paragraph 11, defendant admits he has spent decades working in the comic industry, but lacks knowledge or information sufficient to form a belief about the truth of the remaining allegations, given plaintiff's vague characterizations. Defendant admits that he works on comic books published by Marvel and therefore admits the third sentence. Defendant admits that he has thousands of friends on Facebook and has had various times almost 100,000 Twitter followers, but otherwise denies the allegations in that sentence. Defendant lacks knowledge or information sufficient about the truth in the sixth sentence and therefore denies. Defendant lacks information about the truth in the last sentence and therefore denies. So here you go. Yeah, pretty basic stuff, but you have to get pretty specific. I mean, I guess he would have a hard time denying some of these things. So these are fun. These are lots of fun. The infamous GS says, isn't it funny how you getting mad playing Dark Souls counts as you being psycho for Animat to use as an excuse to not talk with you, yet he refused a Disney film naked and considers himself the sane one? Yeah, I mean, yes, it is funny. It's also funny that he reviewed a Disney film naked in general. Like that's just comedic. Him naked is funny because it's horrifying. Also, it seems weird that he would do a video reviewing a Disney film, which presumably would be marketed towards children, like his video. The review of a Disney film would be towards children and families, I would think. But then he's nude in it. So is he trying to be naked in front of children? I don't know. That's disturbing. He should maybe look into that and get some therapy. Defendant lacks knowledge sufficient to form a belief about the truth in paragraph 12 and denies it. Though defendant notes with regard to the first sentence, plaintiff's own conduct belies the allegations. Okay. So here, this is about Meyer's not politically motivated, just believes political agenda should not be in comics. The number of stores specializing in comic book sales. Clearly the product being generated. So belie means to expose the lie, right? It's what shows the statements to be a lie. So apparently they're saying that Meyer's own conduct runs contrary to this, which is silly because that's not true. There's no politicization in Meyer's comic, right? And anyway, but yeah, so doesn't know anything about it, but it's his fault. Legal documents are so weird. Defendant admits that he's been critical of plaintiff at various times, but defendant otherwise lacks knowledge or information sufficient to form belief about the truth of the allegation in paragraph 13 of the amended complaint and therefore denies the allegations, though defendant notes that such characterizations as alleged by plaintiff are supported by plaintiff's own words and conduct. I don't know anything about him, but I do know that he's guilty of what I said. So yeah, by late 2017, media reports began to emerge characterizing Meyer as a bigot, a racist, part of a group that promotes white supremacy. Various times, Waid has described Meyer as a serial harasser of women and minorities, claimed that he promotes hate and intolerance. These statements were intended to discredit Meyer. So he says, such characterizations as alleged by plaintiff are supported by plaintiff's own words and conduct. Defendant denies the allegation of Waid's interference with Antarctic press set out in the heading at C in the amended complaint. So he doesn't like this. He doesn't like that. Okay. So paragraph 14, he doesn't know, right? And I'm not gonna hang through a lot of these things because again, I don't know enough to know what you're even talking about is the common answer in a lot of answers. One thing you'll actually see in many answers, more commonly in state courts than in federal courts, But you'll just see that they admit who they are and where they, where they live, or that they're in a state or whatever, and they'll deny literally everything else. Deny. Flat denial on everything. And someone just asked, a Spectre of Comics just asked, is there a penalty for lying this heavily in court documents? No. If everybody who lied in a pleading, your complaint or your answer, had a punishment, everybody would be in jail. Everybody who went to court, right? Because the lie is determined by finding out the truth, the facts, and that's the judge's job. So these are positions more than factual statements, is a way to kind of frame it in your head. This is my position. This is their position. So it's not really a lie, because you're denying that you're responsible for your actions, or you're saying that someone else is responsible for the particular action. If we were wrong and then punished for it, it would be antithetical to the court process. So, you can, I shouldn't say that no, you can get in trouble for it, but this is not it. Like, this is not what that would cover. It would have to be an actual lie about a material fact, not just a statement of not knowing. But even that would be tough. You'd have to prove that the lie was prejudicial and all that stuff, and it's a mess. Okay, so defendant doesn't have enough knowledge about the first sentence and denies the rest of 16. Crowdfunding campaign officially closed on May 9th, 2018. He has no idea about that, which is fine. And then he has no idea about Meyer and AP agreeing on terms for publishing Jawbreakers. They agreed that Meyer and his team would produce a book, the 50-50 split and all that. He doesn't know anything about that. 17, he lacks information. 18, he admits that he tweeted to his followers regarding Antarctic Press, but denies the allegation that he did so to interfere with the impending publication of Meyer's book. States that any tweet speaks for itself. Defendant denies the remaining allegation in paragraph 18 of the amended complaints. So yeah, he admits to tweeting, but he says that the tweet speaks for itself, and he denies everything else. So I have a call into Antarctic Press until I hear back. I'm hesitantly willing to give them benefit of the doubt. They don't really understand who or what they're getting into business with, which, though it would seem a stretch, is a possibility. If I do hear back, I'll report in. So, of course, here he's admitting that he does apparently understand who or what they're getting into business with. So that's mildly contradictory, but whatever. Let's see. Defendant admits that he spoke by phone with someone identified as being with Antarctic Press, but he otherwise denies the allegations in paragraph 19 of the amended complaint. So let's see. Waid spoke by telephone with one of the owners of Antarctic Press and convinced him that Antarctic Press should repudiate its contract with Meyer. Frightened for its very survival by Waid's threats, and primarily because of his unwelcome interference, he caved to Waid's pressure and issued the following statement. Almost immediately following the press's announcement, perhaps having been warned that his interference was actionable, Waid deactivated all of his theretofore quite active social network accounts without explanation. Now, he says he didn't do this, so that's interesting. They probably just overlooked that line. It's not going to come back to bite him or anything, but they should call him on it. Didn't you do this? If it ever comes to it, we don't even know. That would be something that to get into an interrogatory, force them to respond. Why did you deactivate all of your social media? Because blah, blah, blah. Well, in your complaint, you said this, or in your answer, you said this. But yeah, so interestingly, he denies this too. He denies that Antarctic Press issued this statement, which is weird that he would deny that, because he celebrated the statement. I think he retweeted it. Let's see. So that was 1920. Defendant denies the allegations regarding interference with Meyer's contract. Otherwise, he lacks the knowledge to form belief, and then denies paragraph 20. So here you go. This is about Meyer. So yeah, he wouldn't have any knowledge of this. Very normal. Oh, I didn't want to do that. I actually just want this back here. Sorry. I clicked and dragged on Adobe and it ruined everything. Here we go. 21, defendant denies the allegation of due to Waid's interference. He's going to deny that every time. That's the basis of the lawsuit, so very important. Allegation of as a result of Waid's action, the allegation of as a direct result of Waid's action or interference with Meyer's contracts, the Antarctic Press, and false statements. Otherwise, he lacks the knowledge and denies. Okay. Defendant. So here's an interesting one. Mark Waid's continued defamation. Paragraph 22. Defendant admits that he participated in a question and answer session with a panel of comic book creators in Houston, Texas, where he spoke about plaintiff. Defendant also responds that the valid recording of what he was said speaks for itself. Defendant otherwise denies the remaining allegations in paragraph 22. So he admits to speaking, and there is a recording, and he says the recording is its own thing and it's sufficient. So that what's on the recording speaks for itself. And if you don't think that that's going to become an issue, that's going to become an issue if this thing moves through into trial, which would be if they don't settle it, it'll go into trial. Or if they don't get summary judgment. But it'd be very hard to get summary judgment. I should probably talk about that. All right. So here's the deal. Summary judgment is a process by which we eliminate the fact finder, right? So the fact finder is either a judge or a jury. Judge or jury are the fact finder, and if you, that's their job. Their job is not to decide what the law is and any of that stuff. Their job is to determine the facts of the case. And then once you determine the facts, you can apply the law to it. Did X person shoot this person? Did it cause bodily harm? Did they intend to shoot this person? All of those things. Once you've established those facts, it's just a matter of plugging them into a statute or a set of common law, which is done, and that's how judgments are rendered. But it's all about finding those facts. Summary judgment is a process by where both of the parties agree on all of the facts that are material to the questions of the case. All right. Once that happens, you don't need a fact finder because you guys agree on the facts. You just disagree on how the law should be applied. And it's up to a judge to come in and apply the law accordingly. Right? That's what summary judgment is. Okay. It's very important in your answer to create issues of genuine material fact. Genuine issue of material fact. It's very important to create those. Otherwise, you'll lose on summary judgment because the complaint gets to allege all of the facts, right? So the complaint initially lays out the factual setting. So in your defense, in your answer, you want to make sure that you disagree with the factual status that's put up on the material aspects of the case, right? So for defamation, did you make the statement? Did you publish the statement to a third party? Was the statement defamatory or was it truthful? Did it cause damages? Did you act negligently or recklessly? You have those 5 sort of issues in there, and you want to make sure that you lay out specifically that you disagree with their characterization of the facts that resolve those issues. If you agree with their facts, unless they've poorly drafted their complaint, which sometimes happens, you're going to lose. Okay, so it's important to raise those issues. If you raise those issues, you'll get past summary judgment. Now, in defamation claims, it's really easy to get past summary judgment on at least a portion of the issues. Specifically, damages, right? You have no idea if your statements, even if you said them all, even if all of that happened, you have no idea if your statements cause the damage or how much damage they cause. So you're going to disagree with their characterization, and that issue will need to be resolved at some point. Okay? So that's what the purpose of this document is doing here. That's why they're denying everything. And to be fair to Waid's attorney, they've done a decent job of that. They've done a decent job of that. They're doing what they're supposed to do, and that's good to see. It is good to see Waid getting competently represented. It's funnier if he's incompetently represented, but he has competent representation. Ryan Pierce is doing his job here. Okay. So yeah, 1 second. Sakaki Onsai says, here's a U.S. grant to celebrate my FTE promotion. Now they can't fire me. Oh, hey, good job, buddy. Now, Waid states he lacks knowledge and information. That's an understatement. He's fatter than Cat Tucson and can't touch Peter David or John Burns' skill. Hashtag rock me Amadeus. So there you go. Thank you very much, Sakaki. But yeah, so that's remembering as we're reading these documents, that's the most important thing. But let's check this out. So Waid has described the events of May 11th in interviews and on comic convention panels. Without limitation, Waid participated in a Q&A session with a panel of comic book creators in Houston, Texas. There, Waid was asked about Meyer and AP. Waid spoke for approximately 5 minutes, recounting his version of the events leading to AP's decision to drop Jawbreakers. After confirming that he was talking about Meyer and his artist collaborator, Waid made the following statements. So Waid says the recording speaks for itself. So he's not going to admit to this summary characterization of his statements. He'll say there's a recording there, and you know every one of these ellipses is a gap. So they'll want the recording. And so he's going to deny everything else, that he defamed Meyer and all of this stuff. Let's see. Otherwise denies the remaining allegations. Okay. So he denies that he defamed him. He is apparently, he's saying everything else. He's like, yeah, well, the recording says what it needs to say. So that's how that goes. And the next thing are just the causes of action. Deny the allegations in the cause of action right here for TI, defamation, exemplary damages, all of that. They just deny all of that. And then there's a jury demand. Relief requested. No response is required to the items of relief requested or the prayer. To the extent that any response is required, defendant denies the plaintiff is entitled to any relief. Defendant relies on plaintiff's request for a jury trial on all issues so triable. Wherefore, defendant Mark Waid requests that plaintiff Richard Meyer take nothing, that the court dismiss his claims with prejudice and enter final judgment in defendant's favor. Defendant be awarded his costs of suit, including attorney's fees. Defendant be awarded such other and further relief that the court deems just and proper. This is a very standard prayer for the defendant. And then here we get to the most interesting part of the document. Okay, these are affirmative defenses and other defenses. Like, what is up? Even if the court determines I did this, I'm legally justified to do so. That's an affirmative, or that could be an affirmative defense or a regular defense. And we're going to look at those. This is the bulk of the document that's going to kind of tell us what their argument looks like and see where they're going to attack this thing in the coming days. Here we go. By alleging the defenses below, defendant Mark Waid does not thereby allege or admit that he bears the burden of proof with respect to any such matters. So he's saying just because I assert these defenses doesn't mean I have to prove the defense, which, I mean, he kind of does. So His first one, this court lacks personal jurisdiction over defendant. Defendant incorporates his motion to dismiss the first amended complaint as well as defendant's objections to the magistrate report and recommendation. So again, preserving this issue on appeal in the answer, not necessarily necessary, but he's preserving it. So good on him for making sure it's preserved. But obviously this objection has been overcome. The court has jurisdiction, has found itself to have personal jurisdiction over the defendant on the tortious interference and on the defamation claims limited to the statements made in Houston, Texas. Plaintiff has failed to state a claim upon which relief may be granted. This is the indicator that a 12b6 motion is coming. That is the Federal Rules of Civil Procedure 12, Rule 12, Paragraph B, subsection 6. So that's 12b6. And that's failure to state a claim upon which relief may be granted. What this is this is saying that, okay, they wrote out this complaint and yeah, they wrote a lot of words, but that doesn't mean the court has the ability to actually grant what they're asking based on the words that they wrote. So a 12b6 motion will follow this document, and that will say the court should dismiss it because this, and this are legal conclusions. This doesn't adequately lay out the causes of action. They didn't actually provide enough facts to make the pleading standards and all of that stuff. They're going to make that motion. We'll see. I mean, I don't know what all they're going to put in there. That'll be up to them to draft that. But this indicates that that's coming. And this is, like I said, this is a standard procedure in federal court. You're going to file a 12b6 motion because if you win on it, you win, and you win with prejudice, typically. Ryan Mercado says, correct me if I'm wrong, but like a motion to dismiss, doesn't a court read a summary judgment motion in the light most favorable to the non-movement and draws all inferences to the non-movement? Yes. Yes, they do. You are correct, sir. All right. Next, plaintiff's tortious interference claim is barred for lack of any valid contract and separately for lack of any breach of contract. In the further alternative, any breach was of Antarctic Press's own volition and not induced by defendant. So they're claiming that there was no valid contract, then there was no breach, and then any breach was AP's decision. So, they may try to incorporate this into a motion to dismiss and fight over the issue on motion paperwork. But you've got your boy Zach alleging there to be a contract. I believe you have AP confirming that they had an agreement. He didn't use the word contract, but I believe he did use the word agreement. And that should be an easy issue to resolve. Question about breach. Well, there seems to have been a breach. If there was a contract, there was a breach because the performance didn't occur. And then any breach is on AP's own volition, not induced by defendant. Of course, this is the defense that he's been relying on the entire time. AP decided it on my own. So what if it was within, half hour of my phone call? Next. Plaintiff cannot establish damages, and therefore his claims are barred. Now, I don't think this is true. I don't think this is an accurate statement. And these are defenses, so I shouldn't say true or false. I do believe that Meyer can establish damages. It'll require expert testimony, right? So what you have to do to establish damages in a tortious interference case like this is they have to take the amount of money that Jawbreakers made on Kickstarter, right? And then they have to take the distribution agreement that AP has with Diamond, because that's the point, right? The point was to get AP's imprint on the book, distribute the book through AP, which would then, through Diamond, put it in comic book shops across the country. And then they alleged a 50-50 split, I believe, is alleged in this. So assuming that 50-50 split is true, then what they would do is estimate the profits based off of any number of things. They would get an expert and Waid would get an expert, and they'd talk about what they might do is compare it to other books or projects that were funded by Indiegogo and then went to the traditional market afterwards. They would look at stuff like that to try and figure out the value of the contract. And then Waid would have a guy come in and say, no, books that are funded on Indiegogo, they don't make any money when they go to stores because everybody who would have bought them ever, they bought them already. So this is all, they would have two different experts that they're each paying thousands of dollars for their testimony, come in and independently testify impartially about what happened. That's how experts work. Just remember, the person that you're paying, say, $2,000 a day to sit down and testify in court, plus flying them there, plus expenses, and they fly first class, of course. And you got to put them up in the Waldorf Astoria. You can't have them not well rested before court. That person is giving impartial testimony that is not biased in any way. It just always happens to be favorable to the person making, or favorable to the person asking for it. It's weird how it works. So anyway, but yeah, that's how they'd have to establish this. But they certainly can. They certainly can establish damages. If there was a contract with a 50-50 split, there's damages. Period. It's just a matter of proving them out. Next, plaintiff's claims are barred because no conduct attributable to defendant was the cause, in fact, or proximate cause of the injuries alleged by plaintiff. That'll be up to a jury. That's the best part of these things. This part and this part, those are jury questions. And if this thing continues to go, and if they fight over it, they'll bring a jury. They will sit down, what is it, Joe Dunn, I think? Whatever, they'll sit down these guys in front of and they'll offer their testimony. Mark Waid will offer his testimony, and the jury will have to determine who is telling the truth. And they'll have to determine if Mark Waid's phone call caused the, is it Dunn's? The Dunn brothers to go ahead and cancel the book. I mean, that's what they're going to have to do. And that's a great system because they get to listen to them talk, and then they get to determine what seems to be the answer. When you have just the day before Anarctic Press saying, we're going forward, we're going through with it, then you have a phone call from Waid and then saying, we're not going through with it, a jury gets to decide if Waid was the cause of that. So next, plaintiff's own words and conduct caused any harm that he has experienced. I mean, he had a book deal, and then he didn't have a book deal. He had a book deal on his own words and conduct, and then Mark Waid opened up his mouth, and then he didn't have a book deal. This is, again, one that'll go to the jury. Well, whose words was it? Richard Meyer had already said the words that they're trying to allege are what caused him to lose his book deal. This is the social justice problem in court, is that, the big allegation is that Meyer called some chick a cum dumpster, right? But he had already done that prior to getting the agreement with Anarctic Press. He already did it. And he got the agreement. And then he held the agreement for a while. And then Mark Waid spoke up. And then the agreement went away. So that's the issue here. What caused him to lose the agreement? Was it his own words and conduct? It's hard to claim that when he had the agreement with his own words and conduct and someone else's words and conduct came out and removed the agreement. Plaintiff's tortious interference claim is barred by the doctrines of justification and or privilege. This is actually not a good defense. for Waid at all. Let me explain what it looks like in a TI case. And I'll tell you how I think they're going to argue it. A justification or privilege in a TI case is when you have someone who is privileged to provide information to one of the contracting parties. So let's put it this way. Let's say you have your relationship with your employer, and then there's a doctor, and you go see that doctor, and then the doctor reports to the employer that you are unfit to perform your job tasks. So your employer either reassigns you or fires you, okay? That could be, in theory, you're like, okay, that's tortious interference. A doctor shouldn't have told the employer about my condition unless either I asked them to, that would be privilege, or the doctor actually works for the employer and the employer hired the doctor to perform the tests on you to see if you are fit for work. That's a privilege. That's justification, right? The doctor is justified in providing this information, or the information is privileged to the employer because of their existing contractual relationship, which hopefully was disclosed to the pleb employee. These are the types of things that are allowed. Now, a similar way this works is, let's say you are a comic book creator and you have entered into a deal with a publisher, and that publisher calls up a major well-known comic book critic, for example. And he says, tell me about this guy, or like an industry expert, and says, hey, I need to know information about this guy because I'm entering into a deal with him. And they say, oh, well, I wasn't going to say anything, but since you're asking, this guy did this and this and this and this, and I don't know if he's a good fit for your company. That's justified. That's a privileged conversation. It's initiated by one of the contract holders, and they are requesting the information from the other person. It can still be defamatory if it's a lie, but if it's truthful information that they're requesting from the person, well, then suddenly we don't have a tortious interference thing anymore, because I'm asking you, you're telling me in response. You're not reaching out to start the conversation. What they're going to probably try and claim here, if I have my lawyer hat on, they're going to do this. They're going to say, look, Mark Waid reached out to Antarctic Press, sure, but he didn't talk to him on the phone. He just said, hey, if he wants to know what's going on, have him give me a call. Then they're going to allege the guy called Mark Waid back, which I think might be factually true. I'm not entirely sure if it's factually true or not, but I think that's the fact pattern we've established so far, is that Antarctic Press guy calls Mark Waid back. So when he calls him back, they're going to allege that that is the justification, that at that point he's asking Mark Waid for input. I think this question fails because Mark made the initial contact. Mark reached out to interfere with the contract. He wasn't just sitting there and owner of AP's like, hello, get me Mark Waid. Yeah, Mark Waid, what do you think about Richard Meyer? That didn't happen, right? That didn't happen at all. This guy's getting bombarded by Waid, by his followers, by all these people. And then Waid calls. Waid initiates the contact. But I think they're gonna try and make the argument of justification and or privilege based on the idea that he asked for Waid's opinion on Meyer. Next, plaintiff's TI claim is barred because defendant merely gave truthful information and honest advice regarding plaintiff. There's case law in Texas that we've covered. I think it's Knox v. Taylor, if I remember right, that suggests that giving truthful information is not a bar to recovery for tortious interference. If you don't have a reason to give that truthful information, then you may be interfering with the contract. And so that'll be interesting to determine. Of course, The truthful information and honest advice is unsolicited still, right? Like, I didn't ask you for this information, and I certainly didn't ask you for the advice. You just gave it because you're a weirdo. Okay. I think this defense still fails because the truthful information is not necessarily factual information. And my opinion is that he's a racist bigot. Okay, that doesn't mean that the guy gets to break the contract or that he was going to break the contract until you interfered. So we still have the same issue. But that's probably what they're going, this is an obvious attempt for TI because under it's either the second or third restatements of torts, truth is a defense for tortious interference. Texas has only adopted the first restatement of torts. It has not adopted truth as a defense specifically. They could do this. I think it's unlikely that the Fifth Circuit will apply this defense that Texas courts have not yet adopted, but it's possible for them to do so. So it'll be interesting to watch, but truth is, as it stands right now, not necessarily a defense for tortious interference in Texas. It's not, because Texas has been protective of its contracts for a very long time. All right, next one. It seems like I keep randomly dropping frames. Is that going on? God, that's annoying. I apologize if that's happening. It shouldn't be, but it very well could be. I'm on hotel internet, so all right. Plaintiff's defamation claim based on social media statements, postings has been dismissed pursuant to the court order. That's true. That's been dismissed. So those are out. This is an interesting one here. Plaintiff's defamation count is barred by his failure to satisfy the Texas Defamation Mitigation Act. This is not true. This is an improper statement on the status of the law at this point in time. By way of example, plaintiff failed to comply with the demand requirements of that act. Plaintiff did not make a timely and sufficient request to correct, clarify, or retract as required by the Defamation Mitigation Act. Thus, plaintiff's defamation count is entirely barred. This is an improper statement of the law, especially in Fifth Circuit courts specifically. I'll talk about this in just a second. Alternatively, plaintiff's claim for exemplary damages is barred by the failure to make requests to correct, clarify, or retract within the time period set out in the act. Now, I don't know if they sent a retraction request. I really hope that they did send a retraction request. It's Waid the Cold One. I know it's called mobile tethering is not actually better than this hotel has really good Wi-Fi, but it might hiccup. That's the thing. But anyway, now you got me all distracted. I hope that they sent defamation mitigation letters. I don't know why they wouldn't, but if they didn't, that's just an annoying mistake. Why would you do that? But that out of the way, if they didn't send defamation mitigation letters to Waid, all right, if they didn't do that, the courts have not held that it entirely bars the claim. There was one case in which the Fifth Circuit Court of Appeals upheld a dismissal of the entire claim. That case is unpublished. It is non-authoritative. It is non-precedental. Okay? So you can't rely on that case for precedent. And you can't rely on that case to make your argument that it should be dismissed. You could cite to it, but it's only persuasive, it's not authoritative. Since that case, which I think was in 2017, the court has several times rejected that categorization. Now, what the court does say is this. Plaintiff's claims for exemplary damages is barred by the failure to make a request to correct, clarify, or retract within the time period set out in the Act. That is true. This is part of it. Okay? So the courts have upheld this statement. The Fifth Circuit Court of Appeals has upheld this statement, as have the Texas appellate courts themselves upheld this, that exemplary damages are barred if you fail to comply with the TDMA. But the entire case being dismissed is not part of the, that's not actually following the court's precedent. So. Yeah, how can you mitigate phone calls and private conversations? Yeah, it's a good question, right? How do you mitigate a statement that was made to comic book creators at an event in Houston, Texas? Don't know. It's a stupid act with a stupid requirement. But arguing that it would be impossible to retract the statements doesn't defeat the act. Even if the person comes in to court and says, I wouldn't have retracted it even if they asked me, that doesn't defeat the requirement of the act either, because that case exists. Like where someone said, no, I still wouldn't have retracted it. They said, but they didn't know because they didn't actually get the request. If they actually got the request, then they would have retracted it. Nope, doesn't matter. You still have to do it. So it's a requirement. If they did it, great. If they didn't send it, they'll lose out on exemplary damages. Exemplary damages that's the multiplier for the defamation. So he'd still qualify for what's called compensatory damages. All right. So any damage actually attributable to the defamation is compensatory. And that can be a big number, right? It can be hundreds of thousands of dollars. It's hard to say. Hard to say how much it is. They'll have experts come in and argue how much damage there was or whatever. Exemplary damage would be a multiplier onto that. So if you don't have the exemplary damages, you're going to get the compensatory damages only. So that's what that means. But this entire argument is not correct at all. The entirely barred thing. The really interesting question will be is if they sent some Defamation Mitigation Act letters, then Waid has to try and argue against them by motion rather than this. And I think he missed his time limit on it. So, but I don't know if they sent them any letters. All right. So next, plaintiff's claims are barred by the applicable statute of limitations. Without limitation of the foregoing, plaintiff's defamation claim based on statements at the Houston Convention is barred by the statute of limitation applicable to defamation claims. I'm not sure when he made statements at the Houston Convention, but it's probably in here, right? Oh yeah, this was after all of this happened. So no, of course not. Of course it's not barred by the statute of limitations. That's a silly one. Because if it happened in May 11th, which was what? April 2017. Where was it? No, it was May 11th. It must have been 2018, but the case was filed in like November of 2018. So, or October, I think it was. So yeah, he's well within the statute of limitations on this. So that's ridiculous. But I guess you throw that out there. Plaintiff's defamation count is entirely barred for failure to allege an actionable statement, as opposed to opinions or other non-actionable statements. This will be a question, this will be a question of, is this an opinion or is this a statement of fact that they're going to argue over in motion practice prior to prior to this going to a jury. So that's a question of law, is whether these are fact statements that are actionable or not. So they will argue this in a motion to dismiss. Plaintiff qualifies as a public figure, and plaintiff cannot show falsity or actual malice. There's no way that your boy is a general purpose public figure. They're going to argue that he's a limited purpose public figure. They may even have a tough time doing that because, well, they're going to use the tweets like my incel army and stuff like that to try and establish the limited purpose public figure. But again, this is going to be a slugfest on whether or not he's a public figure in regards to these statements. It'll be interesting to see what they come up with. Hope they have archives, because I don't think your boy's got a Twitter account anymore. So we'll see. Plaintiff cannot show falsity or actual malice. I think he can show falsity. Falsity that he's affiliated with white supremacist groups? No, I'm not. There you go. I'm not. I'm not affiliated with any. Prove that I am. There's no affiliation. So that's, those are going to be the questions, right? Is he affiliated with white supremacist groups? It depends on how Mark Waid worded some of the stuff. Where was it? Let's see. The publishing of the phone numbers, this stuff. And their phone numbers and the names first and last of all their employees. Well, that's defamatory because he didn't do that. So then, is this just an opinion, man? Like, whatever, man, it's just my opinion that it was all of their employees? No, that's a fact statement. So that'll be interesting. They'll have to argue over that. He can show falsity, though, because he didn't publish the first and last names. Like, he didn't, of all the employees. That's not a true thing. As for actual malice, he'll have to, that's maybe pretty simple, right? There was he could have easily checked to see if they were, he alleged they were all the employees. Did he even look and see how many names he published, etc.? So we'll have to see. Plaintiff's defamation count is entirely barred because any statements were true or substantially true. Therefore, even assuming defendant has the burden of the issue of falsity, plaintiff's defamation count is barred by the defense of truth or substantial truth. Substantial truth is that the publication taken as a whole will be true, even if some little details might be false. Of course, they're going to make the argument over this that even though it says all their employees, well, they just mean an employee or maybe the manager or the owner of the store, etc. So it's substantially true because he said, not all of the, because some of the employees, though. So then they'll have to make a question of whether all or some is substantially true enough. Anyway. Flying thing. So there was a publisher here in Texas who was going to publish the comic after it had been kickstarted, they were going to publish it for comic stores. Seems to know a lot about it. These guys these are indefensible human beings. They harass women. I mean, I guess this is a true or false statement. They harass minorities. That seems like a fact statement. Harass LGBTQ people. They're full of hate. This is an opinion statement here. What are you doing? So anyway, of course they're gonna argue over whether or not these are factual, and then they have to argue over whether they're true or false. We'll have to see. But the best part is, it's a jury question. Meyer gets to go into that courtroom, says, harass minorities. Here are my kids. Bloop, 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 pictures of his kids, right? Then the jury goes, aw, they're all minorities. And then they have to wonder. So if they determine that these are fact statements that can be tested for truth or falsity, the jury gets to determine whether they're true or false. That's a great part. Plaintiff's defamation count is barred because the plaintiff is libel proof. Obviously not. No way is he libel proof. In light of his publicly reported reputation as reported and shaped by various sources unrelated to defendant. No. Libel proof is, again, extremely reserved. Extremely reserved. And if some people said bad stuff about him amounts to libel proof, then everybody's libel proof and we should just get rid of libel altogether, which maybe we should, but until we do, we've got these lawsuits. Plaintiff's claims, including his defamation count, are barred by the doctrine of qualified privilege. I mean, he's not, it's going to be a similar thing. He's going to claim his statements in Houston were made to a crowd. The crowd asked him a question about Meyer, and that gave him the privilege to defame him, right? That's not how it works, but that's what he's going to do. You can still defame someone even if they ask you if it's false. Plaintiff's own acts or omissions caused or contributed to his alleged injury. He had that up above. Plaintiff's claims are barred in whole or in part by the provisions of Chapter 33 of the Texas Civil Practice and Remedies Code. Without limitation of the foregoing, plaintiff is more than 50% at fault for any harm, and therefore his claims are entirely barred. So Texas is a state where I think it's comparative fault. My terminology might be wrong, but basically if you are responsible for 51% or more of the fault, then you're responsible for all of it, according to the Texas courts. Now, some states have a balance scale where, well, you're 51% at fault, but Mark Waid is 25% at fault and someone else is the rest, right? Well, then Mark Waid would be responsible for 25% of the damages. So they would mitigate it. In Texas, if the plaintiff is responsible for over 51%, he's done. He doesn't get to recover. But this is silly. Plaintiff's own conduct, including without limitation, defamation of creators and others in the comic industry. So this is a legal conclusion. I don't know why they decided to put defamation down. That's a legal conclusion. Caused any alleged harm. Alternatively, any fault must be apportioned under Chapter 33 and any damages reduced accordingly. Oh, that's what I was talking about before, the apportionment of damages. So if they do determine that Meyer is partially responsible, then the damages would be reduced proportionate to his responsibility, except for if it's over 51%. So there you go. But again, this is a legal conclusion, so that doesn't really count. But even if so, he had the contract and he had already made those statements. So how can his actions be responsible for something that had already occurred when he got the contract? So defendant reserves the right to name additional affirmative and or other defenses as they are identified throughout the course of discovery. Yay. And then, yeah, same request, that he gets nothing. Dismiss with prejudice, all of that stuff. Oh, excuse me. Mark Zaid is apparently still on the case. Good job, Mark Zaid. Don't think he's done anything in this lawsuit, but maybe he has. Maybe he's secretly masterminded that jurisdictional thing behind the scenes. He said that they would not have jurisdiction. Mark Zaid, super lawyer Mark Zaid, said that the court wouldn't have jurisdiction, and I needed to shut up and wait for their good jurisdictional argument. Boom. So, good job, Mark Zaid. You got that one knocked out. Russian Bot says, remember everyone, the Fast Pass in Disney parks works like appointments. You cannot buy your way into the faster line. You can plan properly with the app and be in the right place in the right time. P.S. Use your own camera. It's not entirely true. You can buy your way into the Fast Pass line. You can. It's just really, really expensive. So that's a possibility. But that's the document we've got, guys. And I'm not going to really go much longer than that tonight. I'm going to read through the super chats and stuff, but I do have an early morning. But let's summarize this document, okay? It's a pretty standard answer. Denying pretty much everything that's written out in the complaint is very, very standard. Nothing to see there. Affirmative defenses, we know there's going to be a 12b6 motion to dismiss. They're going to argue based on some of these other things that he can't allege the elements of the cause of action, specifically damages, right here. Can't allege damages, so he doesn't have a cause of action. They're going to say failure to show that the defendant, or failure to allege, failure to allege that the defendant is the cause of the harm. That should probably fail. That the plaintiff is responsible for his own harm. Again, that's the same thing as this lack of proximate cause. They're going to argue the justification and our privilege stuff on motions. And say, look, judge, we need you to determine as a legal conclusion that we had that Mark Waid had the justification and privilege to make these statements. Therefore, he didn't. Same thing with the defamation. They're going to want the judge to determine that as a matter of law, these are opinions and not facts, and opinions are protected, facts are not. Well, facts are protected if they're true. This TDMA claim, they're going to throw in there. They're going to throw this into the motion to dismiss. It's going to fail to dismiss it, but they will probably get a grant of, they'll get an injunction against exemplary damages. So to the extent that Meyer wins, he will not be able to ask for exemplary damages as his remedy because he failed to follow the Defamation Mitigation Act. That's if he actually failed to follow it. Now, if they sent a letter requesting that Waid take it down, and these guys are just alleging that the letter was insufficient, they would have had to, I believe already, filed by motion, notice that the Defamation Mitigation Act was insufficiently followed. But if you send a letter and you miss objecting to the sufficiency by motion by a specific time, then you forfeit your ability to question the sufficiency. But you do have to send the letter. So we'll see. I don't know if they sent one or not. It's hard to say. Statute of limitations claim will be maybe in there, but this suit was filed prior to the statute of limitations. What they're probably going to do for that argument, if they try and make it, they'll say that the amending of the complaint to add the Houston claims, this is why they're adding this in here, is that the amending of the complaint to add the Houston claims to it was beyond the statute of limitations, and therefore it shouldn't be admitted. And that would be true if it was actually adding the Houston claim to it, but it wasn't. It was a clarification in the amendment. The Houston claims were incorporated into the original discussion, and so this shouldn't be time barred by the 1-year statute of limitation. But that's going to be the argument that they'll probably make. I don't think the judge is going to fall for that, because the judge could have dismissed it already, saying that the amendment put it outside the statute of limitations. I feel like they argued that in their jurisdictional claim anyway, but they could have time barred it there, and they didn't. They're going to argue the public figure doctrine is possibly going to play a part in this this motion to dismiss as well. They may try to make a summary judgment. This may come in through a summary judgment hearing that, yeah, made all those statements, but they're true. And the plaintiff admits that they're true, blah, 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 blah. Libel proof, I mean, they can make this argument, but it's not going to go well for them. Your boy Zach isn't libel proof at all. He can definitely still have reputational harm as shown here. Like, this lawsuit is evidence that my reputation was harmed because I lost a contract. Anything else? No, not really. Long story short, standard document, standard answer. The affirmative defenses are where all the interesting stuff is, and they indicate the motion that we're going to see come out of the opposing party. The next stuff we'll see in this case will probably be some discovery. Well, we probably won't see it. We probably won't see the discovery, unfortunately, unless it somehow leaks online or they have to use part of it in their motion. Then they'll file the requisite stuff. So that's how this next stuff is going to work. We'll have to wait and see what happens at this point, but they've got a long time to resolve this stuff. And I'm talking about the motions and all of that stuff. Remember that their dispositive motion deadline is November 27th. So they could wait until then to file that motion to dismiss. And if their current behavior is any indication of how they will go going forward, they're happy to draw this out as long as possible, because Waid has been drawing this out to try and bleed you boy Zach of funds from the get-go. That seems to have been the issue there. Now, one question is, will they be able to go after Marvel on Discovery? If they're able to go after Marvel on Discovery, are they going to be able to go after Disney on Discovery? Any of those things will be really interesting questions. How high up does this go? And if they're able to effectively go after some of the companies on Discovery, then maybe there will be some pressure on Waid to shut it down. So who knows? We'll have to see. But all right, guys, that's the document. Let's get this. Where are we? Let's get my face back in the image here and less document. Like I said, I am going to go ahead and read through the super chats and justice chats that came in. I thank you all for joining me. If you do check out here for the rest of the show, the full streaming will resume on Friday, but stay tuned this week. Tomorrow, Vic's his appeal brief is due, and I do plan on going through that document as you know, assuming it gets filed, right? I'll be going through that document tomorrow and probably the next day. If I had to guess on the length, it's probably a lengthy document. So if you're interested in the Vic stuff, come hang out. If there's more stuff that drops in Meyer versus Waid, we'll see that soon as well. But regular streaming back at home on Friday. I can't wait. I hate streaming on the road, but I know you guys want to see this stuff about these subjects. And Meyer, we've been waiting a long time to see some documents come out. So, all right, guys, let's hit these chats. I need an adult. It says, oh, I'm gonna move this over. Oh yeah, oh, that's perfect. It's perfect. I need an adult. Says, Nick, can you shill a GoFundMe? This man is in dire need of help, and I believe your audience could really help him. Just search for Get Nick Less Gayer Shorts on GoFundMe. That's Get Nick Less Gayer Shorts. Once again, that's Get Nick Less Gayer Shorts. Thank you. Thank you. So that's lovely. Thank you. What happened to my chat window? Got shrunk. Here we go. Oh, annoying. So apparently someone wants to get Nick, whoever that is, Less Gayer Shorts. Rude. Mercenary X says, just saw the Sum of the Hedgehog movie on Valentine's Day. I think it means Sonic. And it was a love letter, no doubt about it. Doomcock said, without respect, we redirect. I, however, will say with respect, we accept. The studio respected us, had to see. Also, take your kids. I'm sure I'll have to go see it at some point in time, but we'll see. I'm on vacation. Sorry, I thought a kid was running out here. Bunty King says, look, Nicholas DeOrio, I don't know who you are, and quite frankly, I don't give a F. You can screech about me all you want to your pathetic, emotionally stunted audience. You resort to drama content because you literally have nothing of value to offer. Okay. All right. That couldn't be the Bunty King. And I'm not Nicholas DeOrio, but thank you for sharing. That's great. Vine the Cold One, welcome to channel memberships. Very, very fun time. Mario Carter 13 says, review bomb backfire equals highest user rated Switch game. Don't ask questions, just show support by consuming failed product before end of fiscal year. Stooge Muffin Stuff and says, rip Persona 5 Royal. I tweeted out that Persona 5, of course, they are modifying something for the Western release. Now, I'm not a Persona fan. I know a lot of you guys are, and that's cool. I've just never played it, so I don't know. But yes, there's apparently some very offensive to LGBTQ plus whatever situation in it, probably because Western and Eastern cultures are just different. But it's not PC enough for Western audiences, so they have to censor it. So there you go. Deal with that as you will. Karen D, welcome to the channel. Thank you for joining up. Toy Bounty Hunters, good meeting you. Got to do it again. Check DMs later. Yeah, buddy, it was great. Thanks for hanging out. Sorry it was kind of a short time, but I'll check DMs, and yeah, we got to hang out some other time with a little more focus, I think. Jackjaw3695, welcome to the channel. And Jackjaw3695 says, we need to bring back trial by combat. You know, I'm not disagreeing with you. I think, like an MMA match, at least. We don't have to have death matches, although maybe we should. Rural says, you drinking from sippy cup now, Rackets, lol. Yes. You know what I hate most about amusement parks? They're all hippies on straws. I hate paper straws. I hate them. A lot of them, the amusement parks and zoos and stuff, they won't even give you a straw anymore. But if they do, it's that paper garbage. And I hate paper straws. I hate them. They suck. Oh. I gotta calm down. I hate them. Ethan Amante, welcome to the channel membership. Thank you so much. Klondike Pete says, Mark Waid delinda est, misgendering intended. Okay, sounds good. Barb Rogers says, Waid needs to be taken out of existence. Well, I heard he has information about Hillary Clinton's email servers. So, and he also was reporting that the Chinese government improperly handled the Wu flu, the coronavirus. Mark Waid specifically leaked to the world details on how China intentionally created a weapon in the coronavirus and then unleashed it on their own people. I didn't do that. Mark Waid did that from what I've heard. I don't know if that's true or not. But yeah, so there you go. So hopefully he's safe. Some nobody says, Zach is a nobody. Public figure, the edge of my A55. Oh my goodness. By the way, have you guys backed Expendables? That's one way to support your boy Zach through all this. Also, he's got a Patreon page now, right? I heard he was launching a Patreon page, I think. Did I hear that? So if you like your boy Zach, certainly check that out as well. Check out the Expendables book, and you can check out if he's got that Patreon page. Make sure you follow that. Can I find it? Patreon, your boy Zach. Is that it? Richard C. Meyer. Nope, that's not it. Did I hear this wrong? Your boy Zach relaunches Patreon for lawsuit. Oh, go away. Where is it? Here's a Patreon account. Fight back against cancel culture in comic. Oh, he's doing great so far. Goodness gracious. Here, let me send this to you guys. Here is your boy Zach's Patreon. And I'll put it in the description here real quick while I'm thinking about it. We'll get it. Your boy Zach's Patreon. There you go. Save. So there you go. You can check out your boy Zach's Patreon there if you want. Some nobody says, Nick shorts, get that gay from him wearing them. Are you saying I'm gay-tagious? Rude. Rude. Kidda says, Persona 5 thing isn't offensive to LGBT. The joke is 2 characters are hit on by a gay pedophile. Reset Era is upset at offending pedophile. That's no. Of course they are. Of course they are. Austin Heartless says, I've had 2 different kinds of Glenlivet. They're the only scotch I've had that I like. Glenlivet makes a good scotch, man. I'm with you. Spank Daddy, welcome to the channel. Thank you for joining. Raging Golden Evil says, Golden Eagle, Raging Golden Evil, apparently. I can't even talk. Says, I hate paper straws too, so I bring my Trump straws everywhere. Perfect for use in the type of establishment that bans plastic straws. And then finally, insert clever name here says, more correctly, I would say that paper straws don't suck. Lol. Okay. Okay, you pedant. Pedant. Oh my goodness. All right, guys. Gay straws. Every time you drink them, you... All right, guys. I got to wrap it up for the night. Like I said, I've got an early morning. Thank you all for hanging out with me. And I will see you probably tomorrow night, right? Or tonight, whatever time zone you're in, tomorrow night for Vic's appeal brief being due. So come check it out. I'll be here. Maybe I can find a background that's less Spartan than this. This is a nice hotel room or whatever. I should find a better spot, but this is the closest one to outlets. Anyway, we'll talk to y'all later. Sorry for the short stream, but like I said, while on the road, it's really difficult to do long stuff because everybody's that's sleeping children down there, and there's a sleeping lady rackets over there. So over there. So yeah, it's hard to do, crazy stream stuff. Sabin Knight says, I worked for the place you were at. When they rolled out paper straws, I wanted to rent a crop duster, fill it with plastic straws, and $10 of straws and blanket them over the lagoon. Yeah, man, I know. Hey, and sorry I didn't get back to you earlier. I really appreciate the offer. But by the time I got back, I would have gotten back to you. It was already taken care of. So, all right, guys. We'll keep you guys, or we'll see you guys tomorrow. Hope you had a good night. I don't have the outro song on here. Son of a... All right. I'll talk to y'all later. Peace. Peace.